Thank you for tuning in to The Realty with T3. I'm your host, Tisha Harris, and we have a repeat guest today, and we're just so excited to have Catherine Kenjura from Brenham Abstract. And so, who else is with us today?
Michelle Duty.
And so, Catherine, welcome back.
Hi, good to see y'all again.
Yeah, so we're going to really dive into the topics that are really imperative for people in the real estate market and what they can do for estate planning with their families and for their futures.
Yes, I thought it's an important topic. I mean, everyone, it's a necessity to do estate planning, regardless if you don't think you have enough or if you have a ton to have an estate plan. And then in connection with that, to understand if someone dies, that there are different things that need to be completed once that happens, and typically through an attorney to make sure it all flows smoothly, to get the transfer of assets done properly.
Okay, and so let's just kind of just dive right into it. We'll let you just kind of take the lead, because there's so much that is imperative for people to know. So let's just start from the beginning. Somebody buys some property. What are the first things that they need to be focusing on?
Especially first-time home buyer, young, old, anywhere in between. What do you want to happen with that property upon your death? And if you're a married couple or if you buy it with a partner, what's happening to the property on the first one of you to die? What's happening with the property on the second one of you to die? It's particularly important if it's a second marriage and there are children, that one or both of the owners have, or if the family's, different branches of that. Or if it's a married couple and they don't have children, if you don't have a will, then we're in a situation where it's who are the heirs to this property. So estate planning is vital, especially with real estate, and then just in other aspects too, with bank accounts, vehicles, all of your other assets, investment assets. So people typically, it's somewhere, a family member, if you're, planning to have a family, it's important to have a will and documents like that. So they come to me, and typically what we do most is we do a will, we do a power of attorney, which is a financial, or it's a statutory durable power of attorney for finances. We do a medical power of attorney, we do a medical directive. And usually in that meeting, I'll tell them the will work once you've died. The other three documents actually are operating while you're alive. And those are really important. Those three, and I'll start with those, actually help that person or their family avoid having to get a guardianship of them, which can be very expensive and very time consuming, compared to the powers of attorney and that medical directive. So the information I would need on those is, who do you trust? Who, is it a spouse? Is it an older child? Is it a sibling? So we would need that information. Who do you want to handle your financial matters? Who do you trust to not clean your bank account out, to not sell your real property out from under you? Because they can do that with a power of attorney. Who do you trust, to file your taxes on time? Like right now, the season we're in, has that happened? So we need, legal names of those people, addresses, and phone numbers. The same thing with medical. And a lot of times I tell clients those two people might be totally different. You might have one individual in your life that's really good at handling finances and all of that, and then someone else who's really good at medical care, and someone has a child that's a nurse, or a sibling that's a nurse, and or just a child that's more in their skill set. And so who do you want to make a medical decision for you if you cannot make one for yourself? It's so important to have that. Most people believe it is their spouse, and most doctors and all that will allow that to happen. But truly, you are the own decision maker for what's going on with you. So even if you have a spouse, you still need the medical power of attorney to say, yes, this is it. Especially like we talked about on that other situation, a second marriage. I mean, you may have a contentious relationship between a spouse and a child, even if it's their biological parent or a step parent. So who's making the medical decision for you?
Well, I mean, and like you said, like a blended marriage or something like that, it's one of those things that happens that at the time you can be getting along great, but death brings out a different side of people.
It does. Death and illness and unfortunately money is usually the leading that brings that out. So it's, who do you want to get to do that, to make those kind of really critical decisions for you? And then same thing, we do a medical directive, and that actually you make the decision. How do you feel about life-sustaining treatment? How do you feel about feeding tubes, ventilators, that sort of thing? And it takes that pressure off your children or your spouse or a family member.
Okay, so what that document that you just talked about would then make it to where, the person with medical power of attorney would not have to make the decision to, I don't know how to say it, to remove life support.
To pull the plug.
Yes, that's what I was going to say, but I wasn't going to say that.
Yes, yeah. So that
Okay.
it does. It takes some pressure off them, and it's another backup of like, this is how I felt. I don't want you to spend a lot of money, going to extraordinary measures like I want. Most people say, and it's worded, if in the judgment of my physician, I'm not going to make it. The choice is just stop everything except for comfort drugs so that you can go as gently as possible.
Gotcha.
So then those are the three that work while you're alive. We have that will. And there are options too. Wills, trusts. I think we, kind of mentioned trust the last time I was on the podcast, but typically most of the time we're doing a will. And that's, who do you want all of your assets to go to? And a lot of times we see I've got 3 children. I just want them to share everything, share and share alike. Or I have a house in town and I've got 50 acres out in the country, and I'm leaving this child a specific bequest of the house in town, and my other 2 children are to divide the 50 acres equally. The sky's the limit almost on doing a will. If you know what you want to do, we can draft it to say where are your assets going, who to whom is receiving that, and then we need to know who would handle that. That's called the executor, and so they would handle that. If you have minor children, we do things that are called contingent trusts, and usually you'll see people not wanting kids to get money right when they turn 18. Mm-hmm. 18 is young to still get, especially, you're grieving a parent and then all of a sudden you may get a windfall. And so you do a trust to 21, 25, 30, and you appoint someone a little older and more responsible financially to handle that sort of things, like with the real estate. So you have a loss of a parent, you're 18, but we have uncle as the trustee. 18-year-old can't go and sell that property without the trustee jumping in.
Yeah, and I've seen a few times where that the person that's put the will in place, especially if there's real estate involved, like they'll put, even if it's not a minor, they'll make it where it's like 1 to 2 years after they've passed that you can even do anything with it.
Yes, like a little cooling off period.
Mm-hmm.
Make sure that we're making some wise decisions. You always say your trustee's not there to tell you no, it's just to put some guardrails on. You may have a 16-year-old and they're obviously not an adult yet, but 16-year-old all of a sudden, well, I can drive, I'd like a car. Well, we're not going to go get, an $80,000 to $100,000 vehicle. We're going to go find a used vehicle for a reasonable price, and you'll drive that until you're a better driver. And
right.
We're not going to blow everything your parents worked for on an expensive item or a boat or that sort of thing. So Same thing, that the trustee has the ability to, okay, I've been accepted to college. Okay, bring me your tuition bill. We'll handle the payment of it. And just all those kind of life things until they've reached the age that the parent decided they could have the money outright. So that's a contingent trust within the will, and a trustee's handling that. That will would also set out, if you have minor children, a guardian for those children. So who's going to take care of your children if they're under 18 when you die? It's really important to have that. And go ahead.
Sorry, I was going to ask a question about the trustee.
Mm-hmm.
So would they, what would prevent them from spending the money of the child or the heir?
Yeah.
So that's a good question, because you'll hear about things like that on the news or different things like that. You need to make sure who you're choosing is responsible financially and you really trust them, because ultimately they could, and then the child's in a situation where they're having to hire an attorney for what's called breach of fiduciary duty by the trustee. Mm-hmm. You're looking at a criminal matter and you're looking at a civil matter, because they've stolen the money, and that's criminal, and then civilly they've exhausted resources and not taken care of those finances in the way they should have. So just vital that you choose someone that you can trust, and sometimes people just don't know.
Right.
But yeah.
Think you can, and
Yeah,
then you
you
can't.
think you can, then you can't.
Yeah.
So that's what I was saying. You may have someone who's super loving that would be a great guardian, but they're not great with money. So what we'll do is they'll be the guardian of those kiddos, but we'll have a trustee over the kiddos' money. And guardian gets either a monthly or a quarterly allotment to take care of kids, that sort of thing.
Smart.
Yeah.
So when is like kind of the best time that anybody, like, they need to just go right now?
Right now. It's the best time is right now. If you don't have an estate plan, right now you're making an F. If you come and if you go into an attorney's office and start working through it, and even if you sign something that you're like, I don't know if I really wanted that person for this, that, or the other, but you might be at a B+ or something like that when you leave. So, yeah.
Yeah, I think it's just one of those things. It's out of sight, out of mind, and then it's just I think that's why there's so much hostility at the end, is because it could be such a mess depending on how many properties and how much money,
Right.
and
Yes.
if there's kids and blended families. Like, it's a really complex thing.
It is really complex, and the blended family aspect, and there are a lot of those nowadays. It really factors in with where did the property come from? Was it something you bought before the marriage, and that it was with the ex-spouse that's the parent of some of the children in the situation? So, and again, so kind of on the real estate aspect, you have the will, but then we do, along with estate planning, we can do a series of deeds if we need to. We can do ladybird deeds, which are enhanced life estate deeds, and that helps with Medicaid planning, but then it also helps with, who's getting the property. It removes it from the probate. But sorry, I lost my train of thought on there with the deeds. But yeah, if we'll have people gift to their children, or they'll let the spouse gets to stay here and live, and under Texas homestead law, they get to do that anyway. But we'll draft a series of deeds to kind of accomplish a lot of their real estate goals as well. And y'all see that, then when you've looked at a chain of title on a commitment, to where that family plan was going with those goals.
Right.
Yeah.
Okay. So if you could, like, if someone decided, hey, I want to go do this, can you kind of walk us through like the steps and procedures of what they should expect if they were going to come sit down with you, or just, overall, like, as a general attorney in the state of Texas, like, what would that look like if they wanted to go? Now is the time. I pulled the trigger. I'm ready to
Yeah,
start
you
making
made
plans.
the appointment. Come on in. We'll need legal spellings of names. So most people know that. We'll need a general idea of who you want everything to go to. Like, where is that going? Have you thought about that? And that's a conversation, especially a married couple. You really should have it before. I mean, there's been plenty of times I've had some couples sit down and they start looking at one another, and, but that's a conversation though. You should sit down, and carve out time for that kind of, examine your finances and that sort of thing.
For sure.
The other big thing too is guardianship of children. You and the spouse, if there's a spouse, should really have talked about that before you come in. So a general idea of who you want to do that, and then who you want to handle all of that. That's the executor part of it is critical. Who's going to be the person that when you die will help distribute your estate to the people you've named? And sometimes that's the same person that's getting it. Especially, if we all live to 80 and we have 2 kids or 3 kids, that'd be my goal. I've got 3 kids. I'm hoping that at least one to all 3 of them would be the executors of my estate, and they're getting everything once my husband and I die. So that sort of thing. Guardianship, like I said, who's going to be, but basically who it's going to and who's handling it. Same thing too with the contingent trust. Kind of have a feeling, and your kids, especially the older they get, do we think that 21 they would be able to get the money, or do we want to wait till they're 25? And we're pushing it out to 30 more and more now too. That sort of thing.
Can you delegate, like, say they are young, and then like, okay, we're going to allot so much for your college tuition every year, but then so much in like an allowance as far as like monthly living or anything. You can micromanage it however you want.
You could do all of that. We can do all of that, and we encourage, for your trustee to know that plan too. So there's conversations, and same thing too. If you're going to ask someone to be executor that's not your children or just a friend or a sibling, it's good to have had that conversation with them too. And all of a sudden you die, and they look at the will, and you're like, oh, I have a job to play. So those conversations, it's polite to ask.
That's true.
Is the executor always a family member, or can it be the lawyer who drew up the will?
Yes. Most of the time it's a family member or a close friend. It can be anyone. You can even have companies do it, but and yes, it can be the attorney that drew up the will.
Okay.
In those instances, we can't witness or notarize the will if our names appear there to do that, to play that role later on.
Okay.
So what happens, like, I'm just going to throw out examples, like you have John Doe and Sally Doe that like created their will and how everything that they wanted, and they put Mary Sue in charge of everything for their kids, their assets, all of that. But what if something happens to Mary Sue?
So that's
Great question.
That's a good question. I'm gonna push somebody on that too. We need alternates. So we'll say, if Mary Sue dies, John is her executor, but if John dies, Mary's her executor. Well, one of those is not happening. So who's next? Because one's going to die before the other, they're dying together. So we'll have at least 1 to 2 alternates. You can also have co-executors. So sometimes if one of them can't, and you're not under an obligation just because you're named in a will to be an executor. Things might have changed. You might be busy. You might be
Depends on what it is, I'm sure.
Yeah, 90 and have dementia. And so we have plenty of times people waive the right to be executor. You're not forced or required to do that just because you were named in a will.
Okay. So then what happens, you've got that like a kind of like a beneficiary or something like that that's going to go into play. So what would you recommend, like, say somebody's in their 30s, and they have a long life ahead of them. How often should they be reassessing and reevaluating? Because life changes.
Right. Life changes. So rule of thumb is that you need to be looking at your estate plan every 3 to 5 years. I tell my clients, it doesn't mean you're coming in to see me and paying to see an attorney every 3 to 5 years. That's just same thing, that conversation with the spouse, or if you're single, you're looking at it. Has anything changed? Has a relationship changed? Has someone died? Has someone you've named, have they had some sort of an issue, either, a financial issue, a gambling issue, like a dependency issue, like where are we with those kind of things? Have they moved to Alaska and that's not close in proximity, so it's not geographically a good reason to have that. So you need to be looking at every 3 to 5 years.
Okay. I'm going to throw another one at you. Okay. So let's say there's a family in Texas and they've set up their will and everything like that, but their family member lives in another state. Should the person in the executor, for example, the executor lives in another state, like, should they have that looked at from their state bar and attorneys in that state, or it's just where everything is? It's
the county you live in. When you die, that's where you'll be handling a probate. So if the executor's in another state, that's fine. What happens is that you have to, in the state you're in, appoint a resident agent for mail and service and all that. And typically the attorney will say, I can be a resident agent, because that's just more of a service type thing. So we do have executors that live in another state. Typically it's a co-executor situation where at least one of them is here in Texas, so that we're able to kind of quickly, because there's just, even, in real estate documents, even when you're mailing things, there's just that added element of time that's dragging it out, some of that.
Yeah, and then I'm even thinking, like, kind of in the dual state situation, like, not to be ugly towards each other. Like, hopefully it's a cordial, communication between, but if you've got something going on in Texas and then you've got the other person in another state, another country, wherever, just kind of like real estate is, like, you want to have someone that's looking at your best interest, like a realtor.
Yes.
But also, like, for this kind of planning, would you want to have your own attorney look over what some other attorney has sent? Like, not to get ugly, but just to have your best interest put at heart.
Right. And sometimes, like, executors don't get along and they each have their own attorney. So that's typical, and we've seen that. And so they may hire an attorney in the other state. Now, that attorney may not be licensed to practice in Texas, and every state has their own way that a will needs to be drafted. So but yes, I mean, it doesn't hurt to ever have an attorney just take a peek at something like that. Kind of with that in mind too, with the way that a will has to be drafted. You know, if you've moved here from Pennsylvania and you have a Pennsylvania will, it's imperative that you at least go sit down with a Texas attorney to have them look at it. They may not need to redo the will. If a will shows testamentary intent and some different things, there will be reasons why it doesn't have to be redone. But if you've moved to Texas recently and from a different state, I think your estate planning documents need to be examined.
Yeah, so not just your estate planning, but that also would entail like your banking information, because those are all the things you're updating probably anyways.
Yes. So that's good, you know, for all the agents out there, just to make sure that that's something to just say, hey, here's something to think about as you're moving.
So true.
Yeah.
Yeah. So, you know, because of all the messiness you're mentioning when it comes to an executor, I think just in this conversation, I have come to the decision I would like a company to be, you know, somebody that I don't have to worry about moods or emotions or addictions, because there's clearly going to be somebody capable of doing it at the company, you know.
But what happens if something happens to that company or that attorney?
We can still get someone appointed. We'll look for another company. The language of the will allow for that.
Okay.
For another group. The other thing you see with executors too is hurt feelings. So that's
exactly,
you know, you pick older kid just because they're older kid and someone else has hurt feelings. And I wouldn't say that to be appointed executor is any kind of like fun role to be appointed in anyway. And so that person's like, I don't even know why they have their feelings hurt. This has been a lot of work. I didn't, you know, that kind of gets, depending on if the death is sudden, you know, it's something that gets put into your life at a hard time as well, because you have the grief side of death as well.
Exactly.
Yeah, and I think it's just kind of like I've always seen that it's like usually the older kid, and then it's almost like a power struggle of like they kind of knew that was going to be happening, or that was already a conversation with the parent, and it's like as soon as they've passed, they turn into like something completely different of like I control what happens here. Yeah,
exactly.
Yeah,
it is. I know it is unfortunate. So. Yeah.
I bet your job is so fun.
Oh yeah. But then there's some other sometimes not smaller documents, but less used documents. But sometimes people do want, and this is an agent to control their remains, if you know. So we'll do stuff like that every once in a while.
Do people struggle with that?
Some do. I mean, usually if they want the agent to control remains, they know what they want. And they want to make sure they're either cremated or buried in a specific location. But you pick an individual.
So I have to ask. I know there are states, like I know Arkansas does it, but like, is there in Texas, can you be buried like in a biodegradable box, like somewhere you don't have to be like?
So the Health and Human Services Code actually controls cemeteries and where to be buried and things like that. So I'd have to look into the biodegradable thing. I haven't had that pop up with a client yet.
Oh, so but if you wanted, like, say you had a family cemetery, like, there's regulation on that? Like,
yes.
Okay.
Yeah, there's a little bit. It's a cemetery lot is the most interesting piece of real estate you will ever deal with. It is not controlled by the real property code.
Have you ever done that, T?
What?
A cemetery plot?
Not on it, just near it.
Yeah.
They just don't, and more in like a traditional cemetery, they don't pass the same way that traditional real estate passes. There are totally different rules for them under the Health and Human Services Code, and they do not pass under the property code.
So if someone decides, like, I actually want to do a family plot on my land, like, what would be the procedures for doing something like that? Like, is it pretty complicated?
Yes. It's complicated. Yes. I mean, yeah. You need to come see me. We're going to go through and you're probably talking about paying a surveyor and different things like that. Okay. So we're going to have to set it out. So, you know,
it's not like,
I mean, you can't. Yeah.
It's not an easy task.
It is not an easy task. Yeah. I mean, that's why you typically see people we're just going to use.
So it's just like, you know, older properties over time that have been passed down through generations that are going to have that.
Correct. Yeah. And then you'll see it on a title commitment too with that cemetery there. And typically it's, even when you buy property with a cemetery on it, you're not messing with that cemetery. That's typically, so if you're purchasing real property that already has a cemetery on it, I would, you know, take a look at it, because you're going to have to respect that cemetery that's there. You're not taking
and the people coming to see it.
Yes. You're not taking up gravestones or any of that. So, yeah. A few other just pre-death type things that we can also do involving real estate. A lot of times what you'll see is that, and sometimes it would be good to do it if you're looking to sell your property. Sometimes someone's property is separate property. They either inherited it, were gifted it, had it coming into the marriage from another. So you can convert that separate property to community property. And for tax planning purposes or for different reasons. So we do documents. We have agreements to convert separate property to community. So we'll do that a lot in anticipation of either estate planning or a real estate matter. So that's, if you're sitting on a piece of real property and you're like, well, but it's not my spouse's, or my spouse has contributed this way and we just need to change the character of it, we can do that. And then the other document that people don't think of is a real estate document, but it really does factor in, and they don't get recorded, or either, well, one of them may, a premarital agreement or a postmarital agreement. And so they're not necessarily estate planning documents, but they fall kind of in that same realm of just pre-planning for things. I mean, a prenup, as most people call it. I think that people think that that's a scary document, and I don't want to think about divorcing my spouse.
It depends.
Right. I always tell people, and I usually will be doing them in anticipation of a second marriage. And so people have their children. These documents are vital for telling your children what your assets are and what your assets are not. And where spouse has assets, where husband or spouse A or spouse B has assets, that sort of thing. And we put the real property in those documents so that we know this was the separate property. In Texas, income from separate property is community property. So we can change that so if you have a rental house and it's making money, all of a sudden, it becomes community property because you're making that money off of during the marriage.
That's regardless of prenup or postnup?
You get a prenup and we'll contract around that.
Okay.
Yeah.
Okay.
We'll just say that separate property will remain that spouse's separate property. And sometimes that's good for tax matters as well, that we need to make sure we're keeping different money in different buckets at that point.
I've only ever lived in Texas, so
Same.
there are things that are so in Texas that I just think are so everywhere. And
Right.
so I hear people, say, I've never heard of that. So how many states are community property states like Texas?
I don't even know, because I'm only licensed to practice here.
Okay.
If someone comes to me, especially with the Louisiana, because it's like Napoleonic type law, we're going to find you an attorney in Louisiana. Even Oklahoma, I've reached out to Oklahoma or Kansas attorneys on different type matters and said, New Mexico, we're working one deal over there. But yeah, when that happens, we will figure out what county we're in. We'll find an attorney that has a practice similar to ours, and we'll work with them on something like that. It's just, I'm not interested in committing malpractice just to make sure I'm the only attorney on the deal. Right. So I wouldn't even know on the community property.
Yeah.
And it, yeah, as possible.
I don't know. Like, I'm from Missouri, and I don't think that that's like a thing.
That your community property state.
I don't think so.
Mm-hmm. Yeah.
But I haven't lived there in like a really long time.
Yeah.
So maybe things have changed.
Yeah. So that's all kind of beforehand. And then I talked about that Lady Bird deed, and that just makes the property that puts it into the kids' names immediately upon someone's death. Mm-hmm. So, and you'll see those a lot of times, like in a chain of title, when y'all are doing different things, that all of a sudden kids own it by virtue of the parent's death.
Gotcha.
So
yeah. So if let's go forward to the death has actually transpired.
Okay. Yes.
And so, can you kind of walk us through, someone's passed away, they're a client of yours, you may not have talked to any of the people, the executors or any of that stuff. So walk us through the day of funeral, what happens from that moment on.
So typically my client has usually died.
Mm-hmm, yeah.
And most of the time, their children will come back to the attorney that prepared it. Not always. I mean, I've probated plenty of wills for either that other local attorneys drafted, or someone moved here from Galveston County, but they were living in Washington County when they died, so we're probating that will here. You have 4 years from the date of death to probate a will. So sometimes people are grieving and they want to wait and put some time between that. We typically, though, see kind of people come in as part of the business. The funerals also, unfortunately, some of the business of dying too. And so they'll come in within a couple weeks or a month of the death. We need, when that happens, I need someone to bring in the will, if there was one, fingers crossed.
What if they don't have one?
Okay, yes.
Okay.
Mm-hmm. We're going to get to that.
Okay.
Because that's gonna. Mm-hmm. I want the will, and I'd like a death certificate, and then
and those take time.
A little bit of usually by the time someone comes to see us, they've got the death certificate.
Okay.
Sometimes they don't, and we'll say like, "Hey, scan it in, send it to us, or drop it off."
Okay.
So then we sit down. I review the will. I don't read the will like they do in TV and movies. I just sit there. I look through it, and I'll spend some.
Can people write that in their will that they want you to read it like on the
they
movies?
can. They can. They'll have to pay for that. So I'll look through it. If it's one I've drafted, I'll have a general idea of where. And if I've drafted it, I'm not having to review to make sure there's like the power of sale, that the affidavit is self-proving, because those are all things that the wills I've drafted have in them. Mm-hmm. And if it's a local attorney, I know I'm more than likely going to get that, but we'll check and make sure, power of sale, the affidavit self-proving, all that sort of thing. Those are some bigger elements of it. Also, that we didn't just leave out like a residue clause, because sometimes people will attempt to draft their own will and there's mistakes.
I was actually going to ask that question later, because we have a do-it-yourself will drafter CD or something that we've had for years. We've never done it.
Yeah.
And anyways, I totally want to come to you to do this. So anyways, but good question.
Just, so we'll look for all of that. And then once I have a picture of where assets are going to go, I want to know what the assets are. Mm-hmm. And I don't have to know specific value, and sometimes I never know that, but a roundabout value, because we'll get into a taxable estate in a second. And then kind of what those assets are and who they're going to. So once I know that, we will, and if there's a will, we'll go in one of three directions. Sometimes we'll do the affidavit of heirship, and y'all have seen those in real estate. An affidavit of heirship is not probating the will. So it's actually that the assets are not going sometimes. They will go in that direction, but the state of Texas sets out who will get your assets in the absence of a will or a probate. And if I'm going to use myself as an example of, I'm married, and the children of my marriage are also my spouse's children, and vice versa. So in my situation, all of my community property would flow to my spouse. Any of my separate property, my spouse would get a 1/3 life estate, and then the children share the rest of it. So in some situations, and I'm trying not to get too into the weeds on this, it's just more economical if there's just land and we're on a first marriage and the kids are all the kids and they bought that house in town together. We'll do an affidavit of heirship. Now, title companies have their own rules, and your underwriters will too. They don't want to see one of those within 6 months of a death, because they want to make sure we haven't missed anything. So we'll sometimes tell the client, this is what I think we need to do. We're going to save you some time and money and do this, but we're going to set a tickler on the calendar to get you back in here in 6 months, just to make sure nothing's changed. And sometimes in that 6 months, like, oh, we found a bank account that needs a letter of testamentary. Like, that's why we didn't, because then we're doing two things of work for a client, and that's not economical. So we'll look at the assets, affidavit of heirship. There's another kind of hybrid probate. It's called probate as a muniment of title, and it basically turns, for lack of a better word, and I don't know that I want to be quoted saying it this way, but it turns a will into a deed. But you have to go to court, and that might be there's a will from husband to wife, but their kids are, of a first marriage or that sort of thing. So we need an affidavit of heirship would not let that property flow to wife that way. So we'll do a muniment. and we have to go to court. We have a hearing on that, and we'll talk about that in a second too. Or then there's a full-blown probate of the will. And a will is not your last will and testament until a court of law says that it is. Because I might have a will that leaves everything to my husband, but then my grown child took me to a different attorney and I signed another will that leaves everything to just that child. And then my husband and my child are going to fight over those two wills. Typically that's not what you see, but it can happen. So that will, we need to make sure that the court says this is your final last will and testament.
So as soon as you've done it with an attorney or however you've done it, you need to go take it before the judge.
Once you die.
You
have to keep that will I've drafted somewhere very safe. I tell you, either if you have a safe deposit box at a bank, it needs to go there, or if you have something fireproof, it needs to go there at home. It needs to be placed somewhere fireproof.
And someone has
access. So what you see, especially in our county, a lot is gun safes. I'm like, don't go buy another safe, or you can get one on Amazon, a small box one. But put it in the gun safe. And on the safe deposit, make sure someone can get into that. Like, go put your child on the safe deposit box. Because sometimes I'll look at the client and be like, who's on it? That's all. Who's on it? Well, my kids aren't. You have a homework project. You're taking your child to the bank to put them on the signature card. You're teaching your child how to get into the gun safe. Even your 50-year-old child that doesn't know how to do that. We need the combo. We need the key. We need to know where the key is hidden.
Do a lot of people ever just tell you where it's at?
Yes.
And then they may not tell the other person until...
Yeah, we'll make a note in the file. And we found some wills in some weird places. Because someone will die. We know they have a will. We know it. I'm like, you'll find it. You're going to have to keep looking. Because what you see is that someone gets dementia or something, and all of a sudden, this is a really good place under this candle for my will. They'll have removed it. They'll looked at it and just never put it back where it
So what happens if you've done the will, or any attorney's ever done the will, and then it's gone?
We can probate a copy of the will, but it's extra steps and extra work, and if someone wants to be difficult, they can make it difficult. The original wet ink will is what we really need.
Okay. So I hear the word probate. Can you just give me the dummy version of what that looks like?
So we decided, and so probate gets you, it turns that will into your official last will and testament. And that's where you'll hear this fancy term from financial institutions. So from banks or from investment, called letters testamentary. And probate gets you those letters testamentary. It's a certificate that says this is my executor and the will was admitted to probate, on April 11th, 2025. So we have that meeting. We do need to go probate the will. We draft the application. We file it with the county that you lived in. Typically it's here for me, but we do them in all the contiguous counties. That will has to be posted, or the notice that the will was filed, for a minimum of 10 days. We're in a smaller county. We have probate docket every other Monday. It's at 1:30. Y'all could go. It's open court. Court used to be entertainment. You can go sit in on a probate docket. So I'll meet my clients there that Monday at 1:30, and we'll go before the judge. The will is already in there because we filed it, and we'll do what's called a prove up. And we'll say, here's the will, here's who died, and there's a series of 10 questions we go through. Then the judge admits that will to probate. And then that day, that day you can get letters testamentary. We typically will go grab them the next day and give them the client. So then that client will take those letters to the local banks. We'll mail them in to, like a life insurance policy didn't have a beneficiary on it. We'll mail it into them. Oil and gas companies to deal with changing the minerals into the beneficiaries' names. So the probate is making that will, that's kind of the first step in it, is making that will that official last will and testament. So I'll gather all that information and getting it there. And then, hopefully it's a period of about 3 months afterwards where we're helping the executor then figure out the assets and distribute those assets.
Gotcha.
So,
Thank you.
Vehicles, real property, all your investments, and those are different things. You have an Edward Jones or Thrivent, and then you have your banks. So that sort of thing. And then once you've gathered all the assets and you've paid all the bills, then we're like, okay, it's getting divided between the 3 children.
Okay, so we went to probate court on Monday, and so how long should a family or an executor or anyone as a beneficiary, how long should they expect, like, to start, like, seeing those things all taken care of? Like, is it usually a few months?
Few months.
Yeah.
I mean, now there's complications that arise and it can take years. But typically a few months.
Who pays for all of this to happen?
The estate pays. That is an expense of the estate. It's actually, the estate's code sets out a priority list of what gets paid, and all the funeral, attorneys, accountants fees are higher up than other expenses, actually. Like if there's credit card debt, we actually come in before, like a credit card company or a medical bill, that sort of thing. Gotcha. So the estate pays for it. It's not the executor's responsibility, and I really will counsel an executor. Don't pay a bill, and if it's a big one, especially, before you bring it to me and we take a look at this bill, we're gonna pause on that and take a look at that.
Yeah, so maybe you could even like negotiate it and like.
Oh, for sure.
Yeah.
Yes.
Yeah.
Oh, yeah. Well, yeah. So okay. So one of y'all asked earlier, what if there's no will?
Yes.
Okay. So sometimes we can do the affidavit of heirship, because that's still where does, especially real property flow. We can do it with a vehicle too. There's a document online. It's called affidavit of heirship to transfer motor vehicle. We'll do that. If there's no will and you've got money in a bank where they're like, we need letters testamentary, or we've got, a big piece of property with a bunch of heirs where a title company is like, nope, we want a judge to sign off on this. You're doing what's called an administration. And there are two different forms of administration. There's independent and there's dependent. And so what will happen then is client comes in, I don't have a will. They're usually more frantic usually when that happens. That's why you need to get a will, so your kids aren't frantic later. And you have to gather all the information on heirs, because that's who's coming in. But when I say coming in, that's who's inheriting the property in the absence of a will. And what you'll see is that sometimes it's like, okay, person had 4 children, but one's dead and had 4 more children. So we need the 3 children, and then they're going to inherit that. Yep. They're going to inherit that quarter. So we need that. We need addresses. We also, to make it independent, which is less time, have to have everyone's consent to who's going to handle that. So we have to send out waivers to all of them and say, like, are you fine with Aunt handling all of this and being the one that's in charge? Are you, and sometimes they're not. So within the administration, you have to do what's called a determination of heirship. That's why we need that information. So it's kind of 2 things, or not kind of, it is 2 things that are filed. You're asking the court to administer the estate and to determine who the heirs are, who's going to receive everything. If those heirs aren't getting along and they don't want anyone to do it, now what we'll try to do is convince them, let's let someone not in the family do that. And there's some great people in town that we can get to help with that. You're in what's called a dependent administration, and you're asking the court for permission to do everything. Just like, and y'all have maybe seen this in real property transactions. You're having to make an application to the court to sell the real property. Then you're going to have to get the order. Then you're going to have to get the report. Then you're going to have to get the decree. You're talking about 4 documents just on one asset. Same thing with to administer the bank account, to do sell the car, all of that. It becomes probably and very expensive.
I was just going to say, I can't imagine how much cost.
So what I tell, it's so much cheaper or inexpensive, I guess I shouldn't use the word cheap, but to get the will on the front end and to have a probate. And sometimes we don't even have to do the probate, but to have the will is vital.
I have seen so many times in my career that someone will call and say, such and such passed away in my family, whether that be a parent or not, and I want to sell the property. And so we ask them the question, is there a will? Has it been probated? All of these things. And I would say a vast majority of them are a no. Right. And so it's like, okay, well, I know you need cash out right now, but that could take years.
Right. And sometimes, they don't disclose that to y'all either. And all of a sudden they think they own it. You go escrow a contract and then it starts being examined, and all of a sudden it's like you didn't have authority to even enter into the contract, or you only own, you know, a quarter of this property.
Right. And then it's just like you're dealing with heirs that may, like, it could have been from 40 years ago.
Right.
You know, and you're trying to chase these people
Right.
down, and if they're still alive and their family members and
Mm-hmm.
everything. Yeah.
Or just all of a sudden they're like, oh, we didn't like that purchase price. You should have gotten more, you know?
Yeah.
I mean, oh, yeah.
Yeah.
It's important, especially with real estate, to have done proper estate planning.
For sure.
So for a realtor, you're talking to them right now, and like, what would you tell us to do when this situation happens?
I think on the front end, I would make sure that there's been some investigation done to make sure that person is actually the owner to start with, and then I'd send them to an attorney right away. Just see how quickly can you get this completed, and be nice to your family. Let's just get through this. Everyone's going to benefit if we can get the real property sold. That sort of thing, especially if you're dividing something by 40, most of the time it's not going to be a huge chunk at the end of the day based on your sales price.
Right.
And the longer you keep an attorney in it, they're going to get paid out of closing. And so that's just money that's going towards the attorney's bill at the end of the day. So you're just dipping into everyone's cut of the purchase price.
Right.
So I would, and also I'd encourage people to, even if they're thinking about selling their real property and it was an inherited asset, to make sure your ducks are in a row. I would give a 6-month lead time on that at a minimum.
Mm-hmm. Yeah. So for agents, if you're getting these calls or anything like
Yes.
that, do your homework
Yes.
and, just give yourself enough time. Like,
Yes.
even if you open title, like say you got the listing agreement and you open title, like that doesn't really even necessarily tell you everything that you need to know.
It can, but you still might be in a 6-month period of, the worst thing that should happen is that you actually are in a contract and you have a buyer that spent money and they're mad. Mm-hmm. I mean, we see it all the time. They're upset.
As they should be. Or it could be.
Yeah.
All right. So you have really covered everything, like whenever it comes to something that a lot of people don't want to talk about, it's all their biggest assets. Is there anything extra that beyond like before death and after death?
No, I mean, obviously some of this hinges on how much your estate is worth. I mean, the estate tax limit is set really high right now. That will sunset at the end of this year, which is it'll still be pretty significant. Right now it's close to 28 million for a married couple, and it'll drop to 14 million or somewhere in there. For an individual, for a married couple, it'll go to 7 million for an individual on January 1st. But and you're in we're talking about some different things if we're over those numbers right now. But there's some gift taxing and there's some gifting that can be done, and we'll file gift tax returns, and you can do that with real estate as well. Like if you have a big estate, we can start working through some of that with gifting of the real property. Okay. But yeah, I think we covered most of it. I made some notes, and I see that I've said every word on my notes.
I just love this conversation. I could talk to you for days about this. It's so interesting. My husband jokes that I look like a serial killer because of everything I watch on Netflix. Yeah. So this is right up my alley.
All right. I know. It's fun.
Before we sign off, I did want to ask, what is some of the wildest stories that you've ever come across that have taught you so much about death and the type of law that you practice?
I'm trying to say it without violating any kind of confidentiality.
Or can I say, or we can change it if you want to, but I'm wondering, is there ever been a time that something happened and then you it made you feel pity, because it wasn't done?
Yes, I feel pity a lot.
I would think.
I feel pity I feel pity when, it's taking someone forever and they need that money. Like, and
there's nothing you can do.
There's nothing I can do until we finished it. And for maybe it's not the wisest of me, but I typically don't take the money up front, so I'll get paid out of that. But it's when you have to tell someone that they didn't have a will and this is going to cost you X amount of money, and it's almost sometimes not even worth what's even there to do it, that sort of thing, that's sad to somebody that they can't. When if they just had spent a little bit of money on the will on the front end, we did a probate or something a little cheaper, and it would have been, it's just a lot less time on the family too when they're already dealing with that grief. But it's, or you'll see, sometimes they'll see it in a will where they're like shocked that a spouse did something to the, like, as well, or the child that gets left out. I mean, and that's not my responsibility to tell that child why.
Yeah.
Yeah.
It's gotta be hard.
But it's more when someone hasn't done proper planning. That's the worst. It's just, these are things we all have to do as adults.
So if somebody were to come in and they don't have an extreme amount of assets, but a bank account, some investments, a home, cars, what could you even give a ballpark on, like, what it would cost to come in? I'm sure it's much cheaper than if you don't.
Yeah.
And you end up having to do the things you just talked about. So, I mean, I think that probably is a little bit of a scary thing for some people. They just don't know what it's going to cost to go in and do that.
I mean, I would just, look at what they have. That's kind of how I tend to bill. Like, I'll just see what they have, and I'll give them kind of when they come in a ballpark, like with my rate. And then,
Okay.
It made me think of something like we were kind of talking about earlier that I wanted to ask is, like, there's always, with technology and everything these days, there's always that ad that comes out of, like, prepare your bill or your will for $100 online.
LegalZoom. And sometimes, hey, if if you're a pretty basic family and all that, you can try it and see. I don't know that I'm that much more expensive than that. And then you also get the advice of a professional.
Exactly.
And you talk through it. Some of those have come through and landed, and they typically have errors. I mean, we've also seen like non-attorneys try to prepare documents. They have errors. I've actually had non-attorneys like undo stuff that we have done. And then you're spending more money with me or another attorney to, like, correct it again. Like,
you get what you pay for.
You get what I was gonna say. Like, if you want and what is it, like the three things? Like, you can have it done
really
fast, cheap, or done well. But pick two of the three. Like,
yeah, that's true. Yeah. So you've just covered so much. If someone wants to reach out to you to start planning their estate, or if they have any questions about anything that's going on with their property and a recent death, how can they find you?
So again, I'm Catherine Kenjura. I've been an attorney here in Washington County almost 22 years. And this is where I focus on estate planning and probate, and then on real estate. Those are my primary areas of practice. So I am an attorney with the Kenjura Law Firm, and that's 979-836-5297 or ckenjura@kenjuralaw.com. And I am also the owner of, my own with Dan Blaylock, Brenham Abstract. So you can find me over there several days a week, or if you pop in there, and that's the one thing you remember is that she's with Brenham Abstract. Go over there and talk to all of our great employees, and they will direct you to me, or you might find me over there that day as well.
Thank you so much for coming on today. We always love your insights into all of these things that are important that sometimes get overlooked.
Yeah, so I always enjoy talking to y'all. Y'all are great.
Yes, it was fun. Thank you for tuning in. We hope that you got a lot of insight of how you can take care of yourself and your family. And if you want to reach out to us, you can find us at texastrioteam.com. Be sure to like and subscribe and share with someone in your network. Take care and keep living your best life.
Yay! Yay! Thank y'all. I always enjoy these.